Hey guys, welcome to today's Legal 101, being a Wednesday on family and succession law. It's been a while since we spoke. I had indicated on my stories that I wouldn't be able to post between Thursday last week and Tuesday of this week. One, because I was overwhelmed by work, and you might have noticed if you are an avid watcher, listener to this, that sometimes I take that break, but I always inform you in good time. And then number two, it's because hapa katikati nikapata homa, my voice took a beating, so I had to give it a break kidogo. But I'm back, although today's Legal on One will be quite short because I need to do this to pace myself. My voice is still not back to what it was. So we are talking about the principle of suspicious circumstances that can render a will invalid. We are borrowing from a judgment by Justice William Musyoka that he delivered in 2019. And just FYI, Justice Musyoka is one of the best that we have when it comes to interpretation of laws pertaining to family and succession. Okay, and in this particular case, the court wanted to know whether some circumstances that had been described to it were enough to render a will invalid. Now, the court observed as follows: that where the testator is in a testator means maker of a will, if he or she is in a weakened or feeble state that could be caused by old age, by illness, by disease, by intoxication, to the point where they are not in control of their full faculties and therefore they are prone to manipulation. That's an example of a suspicious circumstance that, if probed further, can cause the entire will to be deemed invalid. And especially if there's a propounder of the will, meaning there's a person who's benefiting from this will largely, okay, and as a person who does not feel well catered for, well provided for under the will, you can say that in the weeks, months, days leading to the preparation of that will, this propounder was a person who was taking care of the deceased person, was a person who kind of encouraged them to enter this will, was whispering in their ear, took them to their own advocate, caused their own advocate to execute this will, and it seemed like nobody else was involved, then that's very suspicious, don't you think? Yeah, and especially if you have evidence to this effect, because remember, all allegations must be accompanied by evidence, yeah, and if you provide that before a competent court, then that should be suspicious enough for the court to say, hey, yeah, this will should be invalidated. Now, just to put a caveat there, you know, somebody who's deceased can make an oral before they die, can make an oral declaration. But you see, if there's already an existing will that has never been updated by them or amended by them, then that oral declaration means nothing, okay? So in this particular case, somebody even brought their uncles to come and describe to the court what they thought or what they deemed the deceased had wanted to happen upon his demise. But you see, there's already an existing written will, okay? And then, as we all know, we have seen in very many cases, objectors to a probate process are people who feel disgruntled. For example, a child would feel that perhaps their mother or their step parent has been given so much more than they have been given, or a sibling has been given so much more, or a spouse may feel other people have been given so much more in the will than they have been provided for. But this is not reason enough to invalidate a will. We have Section 26 of the Law Succession Act, which is interpreted by the court when it comes to an application made by a person who feels they've not been adequately provided for. And lastly, on suspicious circumstances, a signature in the will might be different from the deceased person's signature in other documentation. And as a layperson, you might look and say, "Aye, hazifanani, hazifanani," but that's not enough to tell a court. Okay, before a court of law, you will need to get an expert, a handwriting expert, okay, to tell the court, based on my analysis, I went to school for these things. This handwriting is different from this other handwriting. Okay, you can't just say it bila your expertise. Okay. And the reason for that, just to emphasize, is because forgery is a criminal offense. When you say somebody has forged the deceased person's signature on this will, it is very reckless if you do not have evidence. It is defamatory, and so it is a very serious allegation. Okay, so that marks the end of today's Legal 101. I hope you have understood something or you have benefited from this discussion. Let me know if there's something you want me to advise you on. If it's personal, reach out to me on the DMs. I will respond. Thank you and welcome back. Bye.